Good day, everybody. My name is Stephen Long. I am a broker in charge here, wanting to go over the North Carolina offer to purchase and contract with you. I'm going to pull that up and share my screen with you so you can see. I am actually in the Zip Forms platform. If you are not familiar with Zip Forms, it is a place provided to you through your Realtor Association dues that's going to house all of your forms. And I have navigated to the offer to purchase and contract. And I do want to go over this with you just so you have some familiarity with it, feel comfortable with it. The best way to get comfortable with this form is to continue to practice and use it. I will also like to point out that right here under the Form 2G, there is a guidelines for this document, which is a fantastic form. There are guidelines for the offer to purchase, listing agreement, and several other documents, buyer agency, within your form software. Please take a look at those. They have great explanations of what you should put where and why. So this is, of course, me going over it as broker in charge and an agent, but that is a really good resource for you to read through as well. As I'm looking through and kind of combing over an offer, I'm looking for some specific things. One, I want to make sure that we have the parties, the seller and buyers, identified correctly. If you, in fact, are going to list a husband and wife here, you can actually put Jane Doe and wife, or husband or wife, John Doe, whatever you want to put there. But the best way to identify that is if that they are married, because that lets everybody know how the tenancy is set up. They're not siblings, right? You could have people with the same last name not be married, but by indicating they're husband and wife, that's a nice clear way to tell everybody how that should be handled when the title time comes. Likewise, if you are going to have a seller that is an LLC, you would name the company name here, and then it would be signed by a member manager. If you are going to have an estate, then we're probably going to have the executor of the estate sign here. Always check with the attorney to make sure that that person has the authority to sell on behalf of the estate. If this is a trust, then the trustee would be your signature or signer. In this case, it would be in the name of the trust, signed by trustee. Now, in this section, always pay attention to the boxes. You know, where you have a box on any of your forms, it's usually something important. So if it's a manufacturer double add, make sure you include that information from the Form 211T, and that is the VIN number and things that go along with that. Now notice this is our standard offer to purchase. There's also an offer to purchase for vacant land and offer to purchase for new construction. Now we'll not be going over that in this video, but the offer to purchase for new construction, the big thing I want you to know there is that is for a home not built. If you are selling a new construction home that is mostly finished, you will still do this offer to purchase with the new construction addendum. And the new construction addendum combined with this offer to purchase should get all the terms and clauses you need for purchasing a nearly finished home. If it's to be built or not quite going yet, you probably want to do that new construction offer to purchase. That's going to address a lot of different things and make sure that our finished product looks like what we're going under contract for. So there are different offers to purchase. This one will work most of the time. I do want you to be very detailed in your legal description. This is important. Street address, county, zip, as much information in this legal description as you can get, including deed book and page. Make sure you pull a copy of the deed and look at the deed book and page and make sure it is the right deed and for the right property and the right amount of acreage and anything else that might be on the deed. That would be important because anything on the deed is material fact. So if you see something about an easement or sold rights or something, we want to look at that deed, read it, make sure it's accurate. Every property has a deed. Once in a while I get a call, hey Stephen, I can't find the deed for it. Well, there is a deed. You may not be able to find it. You may have to call the Register of Deeds for the county in which it's in, and they can help you find it. They're really good at helping you find things, and they can help find that deed. Sometimes it might be that the deed is for 12 acres and we're only buying 6 acres. Well, that's fine. You can still reference the deed book and page that it's legally described, but feel free to use this other description to say 6 acres of the parcel located at the corner of Main and Walnut as referenced in deed book and page. So you can be as descriptive here as possible. That's really important because in the event of a breach of contract, the seller needs the ability, or the buyer needs the ability to sue for specific performance. So again, we know that if the seller defaults, then the buyer has the ability to sue them and say, hey, you know what, I want you to sell it to me anyway. And that's that specific performance. Well, if it's not legally described accurately enough, the buyer may lose that ability. And that's happened in a couple of court cases where the broker filling out the offer to purchase was not descriptive enough and compromised their buyer's ability to sue for specific performance. Let's not be that broker and make sure we are very detailed here. Now, your purchase price goes on this first line, and then any due diligence or earnest money will go on the next couple of lines. Be sure to mark how you're going to deliver that check, that earnest money check. If you want to do additional earnest money, you can do so. Remember, this is a time is of the essence date. So if you're going to drop in an additional earnest money there, you can do that. If you're going to do a loan assumption, there's a loan assumption addendum, seller financing addendum, likewise a builder deposit if you're going to be doing that. The last line should be purchase price less any of these in between, and that will give the balance of the amount of money that the buyer will have to bring to the closing table, either in the form of additional loan, proceeds of a new loan, or in cash. Everybody initials the bottom of each page. Earnest money deposit is safe. It is going into a trust account and will sit there until everyone has agreed where to put it or how to disperse in the event of closing or in the event of a termination of contract. So earnest money is other people's money held safely in trust by an escrow agent. Escrow agent in this case is probably going to be the closing attorney. It could be the real estate firm if that real estate firm still has a trust account. Some of them still do. But the escrow account or the escrow agent is whomever is going to be holding the earnest money. Also remember that if there's an event or a dispute between the buyer and seller, it will sit in trust. And if it is not dealt with and agreed upon on how to get rid of it, then that escrow agent may opt to release it to the clerk of court. And if it goes to the clerk of court, then it will eventually escheat to the state if not dealt with. So we want to usually get a written disposition with the termination of contract or with the close of how that money should be used. Effective date is the last day that either buyer or seller initial or date this offer. We're going to talk about the due diligence. Most of you know what the due diligence period is, where the buyer will conduct any and all inspections. They can walk away for any or no reason during this due diligence period. For that due diligence period, they're usually going to pay a due diligence fee. It could be zero. It could be any amount. This is 100% negotiable. But if there is any due diligence fee, that needs to be paid directly to the seller. Now, our due diligence period is the amount of time that we are buying with our due diligence fee or otherwise negotiating for the buyer to do any and all inspections that they so choose. This could be an appraisal. This could be a home inspection, termite, radon, structural inspections. They could have general contractors come out, anything that they feel is necessary for them to feel comfortable in buying that house and moving forward to close. We want to get accomplished in this due diligence period. Now notice the bold capital time is of the essence. That means that at 5 o'clock on this date, that due diligence period ends, period. There is no negotiation, there is no extension, there's nothing else. It ends there. Buyer and seller can agree to extend it, but there is no requisite. So that is a very important date. Give yourself plenty of time to have all the negotiations done, all the inspections done, get your appraisal done, get your survey done, anything you your buyer feels comfortable needing to move forward, get it done with plenty of time there. We want to give the seller time to review any repair requests that we may need to make. And likewise, they probably are going to need to get estimates to help quantify what that looks like. So we want to make sure they have plenty of time to do that. There should never be a due diligence request sent over at 4 o'clock on the due diligence date. There's no sense in that because they're going to call you back at 5:01 and decline your request. So make sure everyone has plenty of time to feel good and walk through this without having to rush. Settlement. Settlement is different than closing, and you'll notice that they are defined differently here. Settlement is when everybody comes together to sign the paperwork. The settlement date is the closing date. This is when we want to close, and this is important that this is not a time is of the essence. This is our goal. Our target date to close this is here. And so on the settlement date, we want everybody to try to come and close or sign the documents, and then closing is when it's actually recorded. So for example, settlement date might be at 4:30 on a Friday afternoon. Well, we're not going to get that deed recorded prior to the Registry of Deeds office closing on Friday. So then closing doesn't actually happen until Monday, which closing, meaning the recording of the deed, is when checks can be dispersed, both commission and proceeds checks. Likewise, that's when keys can be given. keys and money do not move until we are closed and recorded. So it is important that we know the difference between closing and settlement date. Also have a conversation with buyer and seller. This is a target. It could move. You need a plan if that moves. Uh, Continuing our conversation, talking about special assessments and proposed assessments as defined. A special assessment might be something like an HOA, a tax assessment, a sewer assessment. And so they come in two different flavors. They're either going to be a proposed assessment or a confirmed assessment. Proposed means they're talking about it. It has not been finalized. A confirmed assessment means it has been finalized and there will be some installment or payment due. Now, remember that, and we'll talk about it in just a minute, the seller will pay confirmed assessments. The buyer will be responsible for proposed assessments. Now, this just goes over the fixtures and exclusions. These are the things that are typically expected to remain as fixtures when a buyer is purchasing a property. And if any of these things do not convey, they should be noted in this contract. But most of the time, a fixture is defined as anything bolted, screwed, glued, or attached, rooted to the property that would convey, excuse me, that would convey and expected to be there after closing. And again, initial. There might be some items that are leased, not owned by the owners of the property. For example, gas tanks, fuel tanks are usually common in this area. Excuse me, I'm allergic to paperwork. So a couple of other things you need to keep in mind are things that do not convey, and these would be fixtures that normally would convey that we would limit here saying, just kidding, these will not. They are going to go with the sellers. The other thing we might want to consider negotiating is personal property. Sometimes there is the refrigerator, personal property, washer and dryer, personal property, couches, tables, different things that are not fixtures that would be personal property that might be negotiated. Be cautious here. You don't want to put more than a couple of things in this area, because if there's a lender, the lender says we're not going to mortgage your living room suite for 30 years. You need to get that off the contract. You can buy it from them directly. That's a different conversation. Usually we can get away with a fridge or washer and dryer here. So make sure you're also very descriptive. So if you're asking for a refrigerator, make sure you try to get the make, model, or information when you're at the showing. Because while you may put refrigerator here and then you go to your walkthrough and the stainless steel smart fridge has been removed and now you have a mini fridge in its place, if all you had was refrigerator, there's no breach of contract. So be very specific with if you are requesting personal property here. I love to try to get a make, model, picture, anything you can. Something present in MLS showings is at least better than just fridge. So try to be as descriptive there as you can. And as the blue box says, make sure your lender is okay with it. The buyer's due diligence is we strongly encourage you to get the due diligence done in the due diligence period. Have a due diligence period. By the way, I should mention on the due diligence period and date, when we're putting in that date, don't put an NA there. So you can have zero due diligence, and you can do it with a very limited due diligence period. But by putting NA, you're saying it's open for interpretation. That might mean there is no due diligence period, or that might mean that it runs all the way till closing. So you should always have a due diligence date, even if you have a zero due diligence fee. So always put in a date. Also talking about the loan and the lender related requirements would also need to be completed during this due diligence period. A buyer should investigate the property to the best of their ability during this due diligence period, which would include inspections, looking at all the documents, any restrictive covenants, bylaws, make sure that they have insurance and can get insurance on the property and it's insurable. Some properties have had damage in the past and may no longer be insurable, so we want to find this out. Appraisal is a big part of that lending and may take time, so they'll have plenty of time to get that done. A survey, make sure you check the zoning, make sure it's going to be conducive to the expected use of the buyer. Make sure it's not in a flood hazard. You have the access to utilities that you require. Usually internet is a big deal there. Streets, roads, are they private, public? Fuel tanks, if there's any leased or available, or if you need to get any of those, make sure you talk to the owner if it is leased and figure out what the terms are and whether you need to perpetuate that or seek elsewhere. If there's any existing property as noted in paragraph 5B, we want to make sure that this contract is not conditional upon that closing, making sure that there's no leases or maybe a lease on a cell phone tower, lease on a gas tank, um, anything like that that would be in hindrance as we move forward. Any repair or improvement negotiations, remember it does say negotiations. There is a repair request agreement that you could do during your due diligence period. But remember, in North Carolina, the property is being sold as is in its current condition. So this is an as is contract. Any repairs or requests for repairs are simply that, just a request as a part of the negotiation. There is no obligation for a seller to fix anything. So reminder to your buyers and your sellers, the property is being sold as is in its current condition. The buyer may very well request those repairs, but it may or may not be something the seller is willing to do. If you are damaging the property during the course of your investigation, you will be responsible for fixing it back. So if your home inspector falls to the ceiling, and it has happened while they're doing the home inspection, you as the buyer and that home inspector are going to be responsible for putting it back in its original condition. You do agree to hold the seller harmless for any of your damages or anything. If somebody gets hurt in the course of your inspections, you're going to basically, if it's an indemnity agreement against the seller, you're there doing your homework. You're not there to potentially put them in a liable situation. You do have the right to terminate. Remember, the buyer can terminate at any point during this contract, not during due diligence, any point. Buyer can terminate the morning of closing, any point. This is an important conversation to have. The difference of what happens is based on our timeline. If the buyer terminates before due diligence period has expired, then they will receive their earnest money back. If the buyer terminates past the due diligence, 501 on the due diligence date or after, they will lose both their earnest money and their due diligence, and that shall be the sole and exclusive remedy to the buyer's termination. That's all that's on the table in the event the buyer terminates, no matter when. It's either earnest money or due diligence. Also important to remember that closing shall constitute acceptance of the property. So if you are not happy with the property's condition when you do your walkthrough, and you should do a final walkthrough to make sure that it is in its best condition or what you would expect, do not close. If the property is not in the condition that it should be, do not close until you get it corrected. So the buyer is going to make a few representations here in the next little bit where they're going to talk about the loan, the type of loan they'll be getting. If they are getting a loan, you would check it here. If they are not, you would say they are not. If they're a cash buyer, I usually choose does not, and then I usually write cash here just to show they are not as an emphasis. If they're getting a loan, you would detail some of that out. The other thing that's going to be important here is whether or not the buyer has to sell another property in which to purchase. There is no longer a contingent sale addendum. That does not exist. So the buyer is either disclosing as a material fact, yes, I do have to sell another property to purchase this one, or no, I do not. If I do have to sell this property, then the next section is going to ask some questions. Give me the address, tell me whether it's under contract, is it actively marketed? I need more information, and you would use that those appropriate boxes there. Again, this is just a reiteration. It's not contingent or conditioned upon the sale of that. I'm just disclosing to you the existence of that need. The performance of the buyer's financial obligation, again, they have to make sure that they are going to get everything they need for their loan, their finances. That is their responsibility to take care of during their due diligence prior to closing. This is the property owner's disclosure statement. So you will either check that they have received a copy of the owner's disclosure statement, or they have not, or that it is exempt. An example of an exemption would be, for example, a foreclosure. Foreclosure, new construction, they're going to be exempt from the residential property owner disclosure statement, so you can check that box and write new construction or foreclosure. Same thing with mineral oil and gas rights. You have or have not received, or it's exempt. Residential properties, all residential properties are subject to the mineral oil and gas rights disclosure. Very few exemptions there. The difference being that vacant land, things of that nature would not require, commercial would not require. Buyer's obligations, you're responsible for the proposed assessments, as I mentioned earlier. You also have some of your own closing costs that are going to be your responsibility, which includes maybe owner association expenses if your lender needs their financials, things like that. You're going to do your appraisal, your title search, your title insurance. These are all kind of expected fees associated for the buyer. The authorization to disclose information is where we are giving permission for the parties to disclose certain things, not anything confidential, but to provide contract to the appraiser if needed. So some of the things that we need to share in conjunction with that purchase, then we're giving that authorization here so that people can do that. Your agents share the closing statement with the agents, which is again confidential. But that's where you're giving the permission to do so. Your seller is going to provide some representations here, meaning that they have or have not owned the property for less than a year, or they may not yet own it if it's an assignable contract. This information will be available to you in the MLS listing if it's an MLS. If we have a lead-based paint addendum, then that needs to be included. We would check this box. Any properties built prior to 1978 would have that lead-based paint disclosure. Now, this is important. This assessments. This talks about any proposed or confirmed assessments. They're either, the only thing we're saying here is that there are or there are not. Do not write none known, if so, seller to pay. That's not appropriate in this capacity because we've already defined what they are and who pays them. Any confirmed assessment, the seller pays. Any proposed assessment would be the responsibility of the buyer. So we're just saying if there are any proposed or confirmed assessments here. And that is all we're doing is identifying those different ones and their amounts. This goes over the homeowner association and whether or not there is one. And just as a notice to the buyer that you're going to probably want to do a little more homework if that is the case, so that you can get any of the information you might need, including their accounting, their restrictions, their articles of incorporation, anything that might be requisite information as a buyer that you'd want to know in purchasing. And hopefully we've got the association information, including the contact person's information included here in the offer to purchase, because everyone's going to need it, including the attorney, so that they can determine how much to collect. The seller has basically an obligation to provide you evidence of title and clear title. And that is usually something that they would be responsible for in the event the title search reveals a cloud on title. That's usually going to be the seller's responsibility. You're authorizing this information, or the seller's going to authorize them, the attorney, to talk to their lender, get payoffs, things of that nature. We will have access to the property lawfully so that we can conduct our due diligence and make sure that we're getting the opportunity to inspect it the way we need to. Now, also, you may have some costs to the buyer to re-winterize, etc., if that is necessary. Also, the seller, this is important, the seller's obligation includes providing existing utilities operating at seller's cost. This also may include de-winterizing if it needs to be de-winterized to run water, etc. So you need to have that conversation with your seller client that the buyer is going to come and do inspections, and this contract states that this is your responsibility to have the utilities on for them. And we don't want to get in a situation where they've come out to do inspections and none of these utilities are on, and then they have to pay a re-inspection fee because they're probably going to want to ask you to pay for that since you didn't have them on as you agreed upon in the contract. The seller should remove all their property prior to closing. This is sends an affidavit and indemnity clause here. If there's a lien agent, if necessary, for like if you're doing new construction, or if there's an issue where you need a lien agent, that's going to go there. Good title and legal access from the seller is needed. Here's where we're going to fill out who the deed is going to be made to. So the deed would be likely made to whomever's in the buyer line of your offer to purchase. But if they're paying cash, it can actually be made to anyone. I, Stephen Long, can purchase a house for my son and have the deed to be made to him, and I paid for it. He owns it. Most of the time, if there's a loan involved, whomever the borrower is and their spouse will likely be the persons who will be on the deed. The buyer agreement to pay buyer expense here is under line I. This is seller paid closing costs on behalf of the buyer. And keep in mind, the buyer has closing costs to pay, which we've already talked about, in addition to their down payment. So they've got down payment and closing costs. The seller will also have their closing costs, including the commission. So this line is a request that the seller is going to continue to pay their own closing costs as expected, but we also need you to contribute X number of dollars towards the buyer's closing cost as well. I always would check with the lender to fill out this information and say, hey, Mr. Lender, my buyer is making an offer on this property, 123 Main Street. How much do we need to request in buyer and seller paid closing costs so that we can be sure to not leave any money on the table? because if they only need $3,000 in closing costs and you ask for five, you've left $2,000 that you could have negotiated off the purchase price or otherwise. So always have a conversation with your lender when you get ready to make that adjustment there. Make sure if you need the FHA or VA addendum that you go over that and review, because as a reminder, if the FHA VA appraisal says, or addendum says, that if it does not appraise at or above purchase price, then the earnest money will be refunded to the buyer. Even if we're beyond due diligence, if we do not get that appraisal back at or above purchase price in a VA FHA situation, then, and they don't agree to lower it to that, because the seller does not have to agree to lower it. That's a request that you lower it to appraised value, or if we terminate, then I'll give you your earnest money back. So make sure you check that out. Talking about owner association fees, if there are any, if you're going to have to incur any fees in conjunction with the transaction or transferring that to a new owner. Any confirmed assessments are going to be paid by the seller. If you have any late listing penalties, or late tax listing penalties, that's going to be the responsibility of the seller as well. Any negotiated repairs should be completed in a good and workmanlike manner prior to closing. This does not say that any requested repairs and agreed upon repairs will be done prior to the due diligence. It just says done prior to closing, hence the reason for another final walkthrough, to make sure that you have time to investigate, i.e. inspect what you expect before you close on that house. So it's in a good workmanlike manner. Under N, the seller's failure to comply with this or breach. If the seller breaches, there's going to be a couple of options afforded to the buyer, one of which we've already discussed. That is the specific performance. I'm going to hold your feet to the fire of this contract, fix what needs to be fixed so that you sell it to me for the amount and terms we've agreed upon. The other one could be what we call compensatory damages, where the seller may have to reimburse the buyer the costs of all the things that they've incurred thus far in conjunction with this transaction, including due diligence, earnest money, inspections, appraisals, or anything else. The goal there is that the seller may have to set them whole back to the original financial condition they were in if they had never made an offer or go down this road as a part of a seller's breach. Seller's breaches are rare, but that is the option that are afforded to them if they cannot complete the transaction. Prorations and adjustments are defined here on how we prorate things like taxes, rents, HOA dues. Those will all be prorated and adjusted at the closing table. The attorney will handle this for you. And the lender. Another thing you may want to request is a home warranty, and this would say that there is not a home warranty being requested or to be provided, or that the buyer may obtain a home warranty of this amount and the seller will agree to pay for it, or the seller has already obtained a home warranty from this company and it costs this much, which would be collected at closing, because most home warranties on the seller side don't have to be paid for until closing. Home warranties typically have limitations. Again, make sure your buyer and seller review the limitations of those home warranties to make sure they're comfortable, because they're not bulletproof guarantees of every system and component of the house working forever. Number 11 says risk of loss or condition of the property. This actually says if the house burns to the ground during contract, the buyer actually has the opportunity to collect the insurance money as is insured to then rebuild, or we can terminate this contract based on that situation as well. So that is a unique opportunity that the buyer could, in fact, continue, assuming their lender is okay with it, and not terminate the contract and be entitled to receive that money to rebuild or any insurance claims needed in that capacity. So number 12 is delay in settlement. This one is important. The settlement delays are not uncommon. This offer comes with a 14-day built-in potential for delay without it being a breach on either party. Buyer or seller can delay up to 14 days past the closing date, so long as both parties are working in good faith towards the closing date. So if they're just doing it out of spite, no, that's not going to work. If we're all trying to make this happen, the loan is not working, I can't get out, whatever the case may be, as long as we are working in good faith, we can extend up to 14 days, which is why I said earlier, this closing date is a target, not a drop dead date. Have that conversation with everyone. There is the opportunity to do a buyer possession before closing or a seller possession after closing. I'm not a huge fan of either of those. Try to steer clear. There's a lot of issues if you have to do that. Again, I've already told you to do a walkthrough, right? Well, what if you do a seller possession prior to closing and you now no longer have the ability to do an accurate walkthrough prior to closing because the seller is still in it And inevitably, their rug, their couch, their furniture is hiding something that you weren't able to inspect. And now you are in possession or ownership of a property that has something that you didn't know about. So those are just scary. Steer away from them if you can. Uh, and also, if you need to do if you have a tenant involved, you may want to consider doing the tenant or agreement additional provisions dealing with the vacation rental and how that's going to be handled, because those do have to be honored for a period of time, even in purchasing a vacation rental. Here's the list of addenda that can be attached to the offer to purchase. And of course, it is unlimited because we have the ability to check this box, which includes attorney drafted addenda as well. Now, this is not the space where we draft. That's not what this blank is here for. This would be to identify a drafted addendum and what we called it. So for example, you might put the COVID-19 addendum here. That is an addendum that is not listed that could be drafted and attached to the contract. Excuse me. These others are the additional provisions or additional signatures, the FHA, lead-based paint. There's a myriad of different addenda that may go along in conjunction with this offer to purchase. Use them as you see fit. You may not need any of them. Lastly, this contract is not assignable without the mutual consent of both parties. It is important to note that our contract in North Carolina, this offer to purchase, is not assignable. So unless both parties agree. If you're doing a tax deferred exchange, i.e. a 1031, you can actually, it's the only time that the parties of this contract can be changed without unilateral permission or bilateral permission, I guess it is. So if the 1031 exchange company is to be used as a party, we can make that change without having to have both parties authorize that. That's the only thing that can happen to this contract without both party approval. And of course, we've defined who the parties are, the buyers and their sellers. Important to note that if the buyers were sellers who are in this contract, something should happen to them, their estate, their heirs would also inherit the contract as well. It does survive in that capacity. It says we've gone over the entire agreement. There's no hidden deals or handshake agreements. We agree to conduct the transaction as described. And execution means that we could actually sign multiple counterparts of this document. And as long as they're all identical, it would constitute one document. So sometimes we have to deal with paper. One person signs a paper copy of this, another person signs another paper copy. If they are identical paper copies, it is considered to be one. This often happens in conjunction with page 14 of the offer to purchase, where we have one person signing for the due diligence money on one page and another escrow agent signing for the earnest money on another page. They are the same page, but they don't have both signatures. So there, in that case, it is still considered execution, even though they're different pages of the same contract. This just goes over how we computate the proration of days. Lastly, down here, we do, of course, always have the signature pages and a wire fraud disclosure. This is important. You should go over it with your agency agreements. Should have already had this conversation with both buyer and seller before we get here, but certainly reiterated at the time of contract, reminding them that you will never, ever give emailed wiring instructions and that they should contact the person to which it is being sent directly and verify it with them. One of the cool tips I heard there is send a phone call, get the wiring instructions, send $5 or $6 via the wire, then call and verify that the proper recipients received it. If so, you have the correct wiring instructions, and then you can send the rest of the money and know that it will arrive at the same location. This is a notice of information section. Most people don't fill this out. The reason you want to have some contact information here, either for the buyer and seller, or at least their agents, is in the event of a dispute, for example, the earnest money, if the trust account holder, the escrow agent, needs to release that money to the clerk of court, he has to have some contact information to send you a letter letting you know that that money has been released to the clerk of court should you go looking for it. Of course, your firm and information, make sure you mark your appropriate agency. If you are working with different firms, of course, it cannot be dual agency in any capacity. The only way to have a dual agency, either designated or dual, is to make sure that you are agents of the same firm, and also put as much of your information and the appropriate opposing agent's information as well, or opposite agent, so that everyone has what they need here for contacts. If attorney needs to contact someone, they have all their info here without having to look it up. Make sure you get the initial at the bottom of that page. And here's the infamous page 14, which I referenced a minute ago, that acknowledges the receipt of the due diligence. And this is where the seller, the listing agent, would sign for receiving that due diligence. If, for example, the due diligence is mailed directly to the seller, we wouldn't need this. We just need the seller. And our goal is to track it and make sure that it arrives at its final destination. So once the seller has signed saying they received it, we acknowledge that that has happened and we are good to go. Escrow agent would also acknowledge the earnest money here, the initial earnest money deposit. If you should need to do additional earnest money per the contract, you would also come back and get that signed by them here at the time it was due. Without any further explanation, obviously there's not any questions because it's just me, and me asking questions of myself would be weird. So that gives you a quick rundown, as quick as I could, of the offer to purchase and contract. If you have any questions, feel free to let me know. I will post this on my Facebook group as well for the notorious BIC, just a fun place I hang out, but also give this to you guys to use at your discretion. But that is our offer to purchase and contract as of 7/2019. We are currently in June of 2020, so this is probably going to get tweaked or changed in the next 30-40 days. But as of right now, that was your review for the 2019 contract. Hope this was helpful. Let me know if you have any questions.